So good morning, everyone. 10:01, we'll get started. My name is Joanna Bogue-Thompson, and I'm one of the partners in the Media and Technology team at Shepherd and Wedderburn. And our Media and Technology team covers all aspects of information management, and data protection is obviously a key part of that specialism. So thank you for joining us for Shepherd and Wedderburn's autumn update on data protection and privacy. And this is an area where things develop so quickly that we're really spoiled for choice every time we pick our topics for these update webinars. I'll do a quick introduction to our speakers because we'll hand over from one to another without further introduction. So first up, we'll have Seraphine Wersch, who's one of the solicitors in the team. And Seraphine will be talking about proposed changes or reforms, as the government would have it, to UK data protection laws. And after that, my colleague Jo Fitzgibbon, who's a senior associate specialising in this area, will talk to you about the practical aspects of using the various transfer mechanisms for international data transfers. So he'll be looking at the IDTA and the SCCs. And if you don't know what those acronyms are, you will know what they are by the end of Jo's talk. I'll then give you an overview of US transfers and the future of US transfers, along with some developments in the EU and the US. And finally, we'll turn to Alison White, one of our most experienced practitioners who lives and breathes data protection law. And Alison will give you an overview of what the ICO has been up to recently. There is a question and answer function on Zoom. So if you have questions, please send them using that function and we'll cover them if we've got time to do that. So without further ado, Seraphine, I'd like to hand over to you to talk about data protection reforms.
Great, thanks so much. Good morning, everyone. Today I'm going to discuss recent updates to the UK's data protection regime. In September 2021, the Department for Digital, Culture, Media and Sports announced plans to reform the UK's data protection laws. The goal was to shape a new data protection regime that would maintain high standards of data protection and public trust without unnecessary burdens for business or barriers to innovation and international data transfers. The proposals included legislative changes which built on key elements of the current UK General Data Protection Regulation, or UK GDPR, such as its data processing principles, its rights for individuals, and its mechanisms for supervision and enforcement. Consultation on this closed in November 2021. Shortly after the consultation had opened, however, the Information Commissioner's Office issued their response, in which they welcomed many of the proposed changes, but raised some concerns over some of the proposals which they thought may undermine the office's independence. In July of this year, a new bill was introduced to Parliament called the Data Protection and Digital Information Bill, or Data Reform Bill, as it's been colloquially called. The bill was due for a second reading in Parliament in September, but this was cancelled for reasons I will come on to, and a new date hasn't been set just yet. I'll now summarize the Data Reform Bill. This bill is intended to simplify and update the UK's data protection network. It aims to reduce the compliance burden on organizations and create more flexibility while maintaining high data protection standards. The bill is meant to lead to about £1 billion in savings for businesses over 10 years. Excuse me. The bill is divided into 6 parts. These are data protection, digital verification services, customer data and business data, other provisions about digital information, regulation and oversight, and final provisions. Some of the most notable and relevant changes to the data protection regime are as follows. Notably, the bill removes the requirement to designate data protection officers, or DPOs. This role has been renamed Senior Responsible Individual, or SRI, and will be someone appointed from senior management of an organization who's not required to function independently from the organization's decision-making like a DPO does. The responsibilities for an SRI are broadly similar, however, to those of the DPO. The narrow range of individuals from which an SRI can in future be designated diverges significantly from the EU GDPR. In practice, this might undermine the obligations to ensure a DPO remains independent and avoid conflicts of interest, but of course, this remains to be seen. Data protection impact assessments are to be replaced with a more flexible requirement of ensuring that risk assessment tools are in place for identifying, assessing, and mitigating data protection risks across an organization. While this is a watering down of current requirements to undertake impact assessments, It's worth noting that the standards set by EU GDPR when assessments are undertaken will not be significantly lowered. Finally, amendments proposed by the bill will allow controllers to charge a reasonable fee for certain data subject access requests, where the requests are vexatious or excessive, or else refuse the request. These changes are intended to widen the threshold from EU GDPR for what requests are considered unreasonable. The bill also seeks to remove what the government refers to as unnecessary barriers to cross-border data flows, though acknowledge concerns around data flows and UK adequacy in the EU, which I'll come on to explain shortly. Nonetheless, the government stressed in their response to consultation on the bill that they believed it was possible and reasonable for the UK to maintain EU adequacy as it designed a future regime. So this data reform bill has now been delayed following the appointment of Liz Truss as Prime Minister, and it will no doubt be delayed further with the appointment of yet another Prime Minister. But I will summarize the reasons for the delay just now. In early October, the then newly appointed Secretary of State for Digital, Culture, Media and Sport, Michelle Donlan, gave a speech at the Conservative Party conference in which she reiterated the government's intention to move away from the EU's GDPR regime and indicated that the data reform bill may be set for even more changes. She announced that they'd be replacing UK GDPR with their own business and consumer-friendly data protection regime. Donlan rejected concerns that had previously been raised concerning the UK's adequacy status. Adequacy is a term that the EU uses to describe other countries, territories, sectors, or international organizations that it deems to provide an essentially equivalent level of data protection to that which exists within the EU. When adequacy has been given, this means that data can flow freely between the adequate jurisdiction and the EU without any further safeguards being necessary. In June 2021, the EU Commission ruled that the UK offers an essentially equivalent data protection to that of the EU and therefore has this adequacy status. The Commission said, however, that it reserves the right to change its mind if the UK diverges its data protection regime significantly from that of EU law. Otherwise, the UK's adequacy status is up for full review by the EU in 2025. Many believe that the UK's plans will allow data protection to diverge too greatly from the EU's for them to be able to maintain adequacy. If the UK were to lose adequacy, UK businesses could stand to lose between £1 and £1.6 billion on compliance costs alone. Donlan said that they would look to other countries who had received data adequacy when looking to reform UK GDPR, those countries which had created their regimes without being based primarily on UK GDPR, such as Israel, Japan, Canada, and New Zealand. Donlan retained her role as Secretary of State for Digital, Culture, Media and Sport under Rishi Sunak, but it's unclear what the fate of the bill will be under his leadership. Given there's been long-standing discussions of the impact of Brexit on compliance with GDPR, it seems likely that Sunak's government will continue to push away from EU GDPR in some capacity. The data reform bill is apparently now paused for further consideration. However, with the next general election set to take place within the next 18 months or so, it's possible the bill will never progress any further. In conjunction with the data reform bill, the government also proposed a second set of rules and regulations for AI and machine learning, which are meant to live alongside the data reform bill and involve regulators such as Ofcom and the Competition and Markets Authority. The UK government's proposed rules address future risks and opportunities so businesses can be clear how they can develop and use AI systems. The proposal featured 6 core principles: ensure AI is used safely, that it's technically secure as designed, transparent and explainable, considers fairness, identifies a legal person responsible for AI, and clarifies avenues for redress. Several regulators, including Ofcom, the CMA, the ICO, the Financial Conduct Authority, and the Medical and Healthcare Products Regulatory Authority, would interpret and implement the principles. These regulators would be encouraged to consider lighter touch options, including regulatory sandboxes and guidance. As with the data reform bill, the future of the plans for AI are unclear with the ushering in of a new government. So this is another space to keep an eye on. So in conclusion, will there be what former Culture Secretary Oliver Dowden referred to as a Brexit dividend as a result of the new data protection regime, which diverges from EU GDPR? While there are potential savings to UK businesses of about £1 billion over a 10-year period if the data reform bill were to go through. Whoops, sorry, my light's just gone off. Just keep going. The potential costs to businesses if the EU were to lose adequacy status with the EU would be at least that much, if not more. Further, we can't calculate the difficulties that would have to be incurred in having to comply with two entirely separate regimes, as compliance with both EU and UK GDPR as they stand is difficult enough. So I'm now going to hand it over to Joe, who will be discussing international data transfers.
Thank you, Seraphine. Well, my job today is to make sure your Halloween nightmares don't continue as you start to think about your international data transfers. And many of you will already be asking, where do I begin when it comes to ensuring your data transfers comply with the changing regulatory landscape? But please be assured, you're certainly, very certainly not alone. So I'm going to discuss the practical issues associated with international transfers, and in doing so, I'll provide a recap of the applicability of the UK GDPR and EU GDPR regimes, and an outline of the mechanisms for making international transfers under these regimes, with a particular focus on standard contractual clauses and the UK International Data Transfer Agreement. So a little bit of background. Well, as you know, after Brexit, the UK replicated the GDPR as the UK GDPR while making adjustments for UK terminology and institutions. And we now refer separately to the EU GDPR and UK GDPR. Organisations may be subject to both regimes, therefore careful analysis is required to determine what regime applies to your organisation when making international transfers. And this will, of course, affect what data transfer mechanism you may elect to use. So what types of international data transfers do you need to think carefully about? Well, an organisation, either a controller or a processor, that is subject to the EU GDPR or UK GDPR, that is transferring or making accessible personal data to another legally distinct organisation that is based outside of the EEA or the UK, is known as a restricted transfer. So these transfers are restricted unless the rights of individuals in respect of their personal data is protected in another way, or one of a limited number of exceptions applies. So guidance from the European Data Protection Board and the UK Information Commissioner's Office has confirmed that, firstly, transfers of personal data by an organisation to its own employees does not constitute a restricted transfer. This covers, for example, transfers to branch offices that don't have a distinct separate legal identity. Secondly, transfers of personal data by an organisation to another company within its group may qualify as a restricted transfer. Further analysis is required in those scenarios. And thirdly, the transfer restrictions also apply to onward transfers from the original third country recipient, e.g., a parent company or a headquarters receiving personal data, then onward transfers that data to a processor will also be caught by the transfer requirements. So let's get back to basics and consider what restrictions the EU and UK GDPR place on data transfers. As you will all know, the EU allows free flow of personal data between member states, including the EEA. Beyond those borders, there's a need to have a data transfer mechanism in place. As Seraphine has already touched upon, adequacy can be relied upon for certain transfers. And adequacy, put simply, means that the EU has assessed that the laws in place in a jurisdiction are of equivalent standard, and personal data can therefore flow freely to that jurisdiction. The good news for the UK, as Seraphine noted, was that the EU granted the UK adequacy in June 2021. The UK GDPR adopted the same adequacy regime as the EU GDPR, and in doing so, all EU member states were deemed adequate, which has enabled ongoing transfers since Brexit. All countries with adequacy approval in place in the EU as of the 31st of December 2020 were also approved by the UK. So far, so good. Going forward, the UK can choose to give adequacy approval to countries that the EU has not, and this could theoretically include countries such as the USA. However, as Seraphine carefully got warned against, any decisions that the UK does make regarding its own adequacy, decisions may affect how the EU views the UK's adequacy. So let's watch this space in the coming years. So what transfer protections or transfer mechanisms can be put in place to protect personal data when it is being transferred? Well, you'll be familiar with the first one, which is binding corporate rules. These are used within group corporate structures. However, their use is fairly limited in practice. For those of you who are avid refreshers of the European Data Protection Board's approved binding corporate rules section of its website, you'll have noticed that one set of DSARs has been agreed in 2022. And this brings the total to 42 since 2018. So again, just to re-emphasize, not a hugely common method to use. The second most common transfer mechanism are the standard contractual clauses, and these will be familiar to many of you, and we will discuss these in more detail throughout today's seminar. The third is a certification scheme, and the first certification mechanism to ensure compliance with the GDPR was published on the 17th of October this year, and it's called Euro Privacy. In order to comply with this, your organisation must document its compliance with the Euro Privacy criteria, and your processing must then be certified by one of Euro Privacy's official partners. It'll be interesting to see how much that scheme is used in practice. And lastly, certain derogations. These are exceptions that exist under Article 49 of the GDPR, can be used for certain data transfers. These are specific and limited in nature and are not really appropriate for business as usual transfers. So let's dive into the standard contractual clauses in a little bit more detail. As I said, these are the most frequently used, particularly for one-off relationships. The EU updated the SCCs in June 2021, and it set a deadline of the 27th of December 2022 to update existing agreements that use these EU SCCs. The new EU SCCs have a modular design in which you can select one of four modules that's appropriate to your transfer. This would be either controller to controller, controller to processor, processor to processor, or processor to controller. As with the old SCCs, you need to complete the annexes. It's not simply a copy and paste job, unfortunately. And Annex 1 requires a description of the transfers, including a description of any onward transfer. Annex 2 requires specific details of security measures implemented to protect the data. And Annex 3 sets out a sub-processor list to be used where the data importer is not given a general authorization to engage sub-processors. So organisations in the UK will be able to choose from one of two different transfer mechanisms when making restricted transfers under the UK GDPR. The first mechanism in the UK, and then the equivalent of the EU SCCs, is called the International Data Transfer Agreement. And this has been enforced since March 2022. So if you've been using the old SCCs purely for transfers of UK protected data, you do not need to replace these until the 21st of March 2024. So we've already got two competing deadlines there. We've got 27th of December this year to update transfers of EU protected data and to move from the old SCCs to the new SCCs. But if, as I said here, you've only been transferring UK protected data, i.e. that is data that falls within the scope of the UK GDPR, you have until the 21st of March 2024 to replace those old SCCs. For those of you who are already dealing with the IDTA, you'll note that it requests much of the same information that would be included in the EU SCCs, including details of the parties, details of the data being transferred, and the applicable security requirements. But it also allows you to add supplementary measures in Part 2 or additional commercial clauses as part of the agreement. As you'd expect from a document that standardizes data transfers, it does contain some mandatory clauses. These are contained in Part 4 of the IDTA, and these cannot be amended. And I guess it's worth just mentioning that unlike the EU SCCs, there's only one set. There's only one set of contractual clauses, not the four-module approach of the EU SCCs. The second transfer mechanism available in the UK is the UK addendum to the EU SCCs. And this permits reliance on the EU SCCs for UK transfers. It contains mandatory clauses to make the EU SCCs work for UK transfers. So why use the UK addendum? Well, it's short and easy to use, and in theory should reduce the administrative burden of juggling two regimes, avoiding the need to have both EU SCCs and the UK International Data Transfer Agreement. In theory, this should be easier to maintain a single mechanism over time. And finally, it should reduce deal friction. And we're generally seeing this in the market, that customers and suppliers have been used to dealing with the SCCs since 2018. So the use of the UK addendum is a relatively small addition to that. And it's worth noting and re-emphasising that even if you're not processing or transferring EU protected data, the UK addendum can still be used. So sitting alongside this, it's important to remember that the use of the IDTA or UK addendum for your international transfers does not remove the need to conduct what is known as a transfer impact assessment or transfer risk assessment. Many of you will be familiar with the privacy activist Max Schrems, and it was the Schrems 2 case in which he challenged the use of the SCCs, which made it clear that a data exporter must undertake a prior, documented and diligent transfer impact assessment to verify on a case-by-case basis if the law or practice of a third country impinges on the effectiveness of the transfer tool used. Those of you who are dealing with this will know that this assessment requires detailed analysis of the nature of the data being transferred, the jurisdictions of the parties, and the data protection regimes that apply in those jurisdictions. And the gathering of this information is used to identify what supplementary measures parties need to put in place in order to protect the data when making the transfer. So what are the practical issues when using these mechanisms? So for those of you who are already grappling with the implementation of these transfer mechanisms and risk assessments, you'll be painfully aware that there's a lack of guidance from the ICO that is not helping matters. The ICO recently stated that it will be prioritising guidance in relation to transfer risk assessments rather than clause-by-clause guidance on the transfer mechanisms. But given the impending December deadline that I've already referred to, this is all very late in the day, and with 8 weeks to go, it's not entirely clear when any of this guidance will be released. So in terms of getting the ball rolling, there are some initial steps that need to be thought through in terms of mapping internal data flows and identifying what GDPR laws apply to certain transfers that your organisation may be undertaking. From that point, it's a case of understanding what transfer mechanisms need to be implemented. And much of that work may already have been undertaken in your organisation, particularly given the GDPR's existence since 2018. As I mentioned before, none of these mechanisms used for international transfers allows you to simply copy and paste clauses into an agreement. So careful thought needs to be given to some of the completion of optional clauses and annexes within each template. There are different ways to incorporate the UK addendum to contracts, and some of you will be preparing your own contracts and also receiving updated contracts from suppliers that will require careful review and a bit of matching to make sure that the clauses are all covered. Decisions will need to be made about how to incorporate the SCCs when using the UK addendum, and this can be done by reference, which is common to reduce contract length, or it can be done by setting out the provisions in full. It's very much what you prefer to do as an organisation. As you'd expect, practice is still evolving, but I don't think the excuse that the ICO has provided guidance will prove very strong as we march towards certain deadlines. So finally, I thought I'd leave you with a little bit of a flavour of what we're helping clients to navigate as we approach the 27th of December deadline. As you'd expect, given we are data protection practitioners, we continue to help organisations map their data flows both internally and externally. As part of that, determining what GDPR regime applies. Is it the UK? Is it the EU, or both? Working out what transfer mechanisms work best for each client. Not all clients are the same, as you would expect. We're then incorporating the SCCs and the UK addendum into contractual arrangements. As I said before, this includes both contracts that the organisation itself are preparing, but also we're reviewing agreements where the incorporation has been, shall we say, attempted by third-party organisations. We're also ensuring that Article 28 provisions are still incorporated. Don't forget, where a processor is being appointed, these also need to be sitting within the contractual matrix. We're also assisting with vendor questionnaires to determine where the data processors are located and what laws they are subject to. This, of course, as I said, will have an impact on what supplementary measures need to be considered. And we're also helping prepare transfer impact assessments. And we're updating privacy notices to make sure individuals understand any international transfers that are taking place when it comes to looking at their data. As ever, we'd be delighted to assist with any questions or issues you may be facing in this area. So I'm now going to hand back to Joanna.
Thank you very much, Joe. So yes, lots to think about on international data transfers and some complexity in there. I am going to just take you through a number of different international areas. I'm going to talk about US transfers and the future of US transfers, and just also some interesting development in international privacy laws. Why am I doing that? Well, the EU GDPR is still very relevant to an awful lot of our clients, and many of our clients are operating internationally. So EU and US tend to be quite important jurisdictions, and also increasingly China. So let me start off with some news on the US. So for the first time ever, the US legislature has proposed the first bipartisan comprehensive consumer data protection law, and it's called the American Data Privacy and Protection Act, the ADPPA. And if it's enacted, the United States would join over 100 countries and also several US states that have already enacted comprehensive consumer privacy legislation. So it's actually a big step. The privacy geeks amongst us will know that several US states already have privacy laws. Probably the best known privacy laws are coming out of California, and these include the California Consumer Protection Act and the California Privacy Rights Act. And that legislation empowers citizens to review what personal data a company has on them, to track who their data is sold to, and also to sue technology companies for violating their privacy rights. So there's already some consumer protection legislation for privacy in the US, as I said, in California, but also in Colorado, Connecticut, and Virginia. And so quite a lot of attention on the new ADPPA has been focused on enforcement mechanisms and whether it would preempt existing state legislation that consumers have already got used to. So the ADPPA is on its way, but it's still got a long way to go. However, I do think it's interesting to see that the US is considering countrywide federal laws on data privacy. And what does that mean for US transfers? Well, so far the ADPPA is not going to have any effect, but there is some good news, and I'll come to that just shortly. So let's go back and look first of all at EU and US transfers. So once upon a time, we had safe harbor, and that just seems like forever ago now because it was invalidated in 2015. And then safe harbor was superseded by Privacy Shield, but lo and behold, Privacy Shield was invalidated in 2020. And so there are two big issues in terms of transfers to the US. And the first issue is whether US companies, so that's tech giants like Google and Facebook and its parent Meta, can store information about Europeans in the US. So can a US company store information about Europeans in the US? And secondly, and just as importantly for all of us, whether EU companies can use US-based technology providers. And if you think about most of the big tech providers, at some point you'll be touching Google, for example. So as Joe's mentioned, at the moment, you need a transfer mechanism from the EU to the US, and most often that will be standard contractual clauses. However, there is some good news on the horizon, because on the 7th of October, the US President Joe Biden signed an executive order, and that brings the possibility of easier legal means of data flows from the EU to the US much, much closer. It paves the way for a possible adequacy decision from the EU. And of course, as Seraphine said, if adequacy is granted, that means that our friends in the EU would be able to stop using the SCCs for transfers of personal data from Europe to the US, and they could rely on adequacy instead. It would take about 6 months for that process to go through. It would be subject to a vote, and it's not likely that we would see any adequacy decision for the US coming out of the EU until at least March next year. But it would be tremendous news for the many European companies who want to transfer data to the US, and also for US tech companies. So there's potentially some movement there in terms of adequacy for the US so far as the EU is concerned. But of course, we in the UK will not automatically grant that adequacy. And so what's going to happen if the EU grants an adequacy decision? Well, the answer is that it's really down to the UK government. And the UK government has welcomed the publication of the executive order. And they've said that it strengthens the safeguards and establishes new redress routes for UK data processed by US authorities. And so in October, following on from the executive order, the UK government said that it intended to work expeditiously and that it's making preparations for the laying of adequacy regulations in Parliament in early 2023. And that will sit alongside the issuing of guidance for organisations and individuals. So if, maybe when, but if adequate decisions are issued by the European Commission and the UK government, that will allow a framework to come into operation. And under that framework, US companies can seek to be certified by the US Department of Commerce. And so the obligations in relation to the framework aren't out there yet, but we expect that certain core GDPR type principles will be amongst them. For example, data minimization, purpose limitation, and certain data subject rights. So we're still some time away, but actually there's, I think, the possibility of some optimism around adequacy for the US. What you might not know so much about is the UK-US Data Access Agreement. There is in fact already a data access agreement in place between the UK and the US, and it came into force last month on the 3rd of October. And that data access agreement allows UK and US law enforcement to request data held by telecommunications providers in each other's jurisdictions. And the idea is that it allows US and UK investigators to gain better access to data necessary to combat what is referred to as serious crime. So that's crimes such as terrorism or transnational organised crime and child exploitation. But this seems like a good thing, but it could have an impact on the UK's adequacy status under the EU GDPR. And again, Seraphine talked a little bit about that. And she mentioned that the European Commission has said that it will take account of any developments as part of ongoing monitoring of the adequacy decision granted to the UK. So at the moment, we have two potential issues, I think, in terms of the UK's adequacy decision and our ability to transfer data backwards and forwards with the EU. First is the data reform bill that Seraphine talked about, and the second is the application of this data access agreement. So quite a lot happening in terms of the US. What's been happening in Europe? Again, lots of activities. So the European Commission proposed two legislative initiatives in December 2020, the Digital Services Act and the Digital Marketing Act, and they work together, and they've got two main goals. The first is to create a safer digital space in which the fundamental rights of all users of digital services are protected. And the second is to establish a level playing field to foster innovation, growth and competitiveness, both in the European single market and globally. And so, for example, the Digital Services Act requires hosting service providers to enhance their responses to notices of allegedly illegal content, so takedown types of notices. And online platforms also have to apply know your business customer principles. And that means a degree of verification of certain trader traceability information before they're allowed to use the platforms. The Digital Services Act has been approved by the Council of Member States, and the final text is expected to be published in the EU Official Journal this month for an entry into force 20 days later. And this will then apply to organisations after a 15-month transition period or the 1st of January 2024, whichever is later. So doing the maths, it'll be a 15-month transition period. And then the Digital Markets Act is more about gatekeeper online platforms. It's actually a step ahead. It comes into force today, the 1st of November, and becomes applicable 6 months from today. A couple of cases I want to talk about. The first frankly scares the living daylights out of me, and it's on legitimate interests. So a lot of us use legitimate interests as the legal basis for data processing under EU GDPR or UK GDPR. Legitimate interest requires a balancing test, and that means that you need to ask this question: is my legitimate interest overridden by the rights of the person whose data I want to process? And that can be quite a challenging test to apply, and we do legitimate interest assessments to try and work out where that balance is. And in late September this year, the Amsterdam District Court referred some questions to the European Court of Justice on the interpretation of legitimate interests. And this is potentially huge, because the legitimate interest gateway is used by thousands of companies for thousands of transactions. So in this case, the Dutch Tennis Association received a fine of €525,000 for selling the personal data of its members to two sponsors. And following an appeal by the Dutch Tennis Association, the Amsterdam Court has asked the Court of Justice how it should interpret the legitimate interest rule. And at issue is the question of whether a purely commercial interest can be a legitimate interest. And the Dutch regulator has stated in its guidance that a purely commercial interest cannot be a legitimate interest. And that is terrifying. Now, the European Commission has argued that the Dutch regulator's interpretation is not in line with EU GDPR, is not in line with guidelines from the European Data Protection Board, and is not in line with case law of the Court of Justice. So the European Commission itself is significantly at odds with the Dutch regulator. And if purely commercial interests are not held to be legitimate interests, that could have a very significant impact on a lot of data-driven businesses. Another case that's quite important is about damage for distress. And you'll remember from our previous updates, the case of Lloyd v Google, where the UK Supreme Court rejected the proposition that compensation for a data breach was payable for infringement without proof of damage. Now, that case was decided under the pre-GDPR regime, so under the Data Protection Act 1998. Excuse me. There is now a case that relates to the Austrian Postal Service. Apparently, for some years, the Austrian Postal Service has used an algorithm to determine whether individuals had an affinity to a particular political party. And that was based on certain socio-demographic features of their address information. Excuse me a second, I'm just going to clear my throat. And one individual claimed compensation under the GDPR on the basis that the conduct of the Postal Service caused him great upset, and that the political affinity that was attributed to him was insulting and shameful, as well as extremely damaging to his reputation. Now, the Advocate General in that case has issued their opinion, and the Advocate General's opinion is that infringement of the GDPR alone does not give rise to the payment of compensation. And in particular, the Advocate General concluded that the individual must have suffered damage as a result of the infringement in order to trigger compensation, and that there is no presumption of damage having occurred as a result of a breach of the GDPR. So we're awaiting the decision of the European Court of Justice on this one. For companies who are faced with what they often view as frivolous claims for damages, I think there's some cause for optimism. But by contrast, privacy campaigners are horrified and claim that if the Advocate General's opinions followed, it would hamper the possibility of seeking compensation when an individual has suffered non-material damages such as reputational damage and emotional distress. So a lot's still happening in this area, and I think we want to watch this space. And then I want to talk just a little bit about the European Data Protection Board's latest consultation. And that is a consultation on an update to its guidelines on data breach notification. The update is pretty minimal, and it focuses on the expectations on data controllers who are subject to the GDPR but are based outside of the European Economic Area. And the proposed changes would mean that any data breach would have to be notified within 72 hours to all 27 supervisory authorities, rather than just the one, which is what's allowed at the current time. And the view of the European Data Protection Board is that non-EEA-based controllers should not get the benefit of the one-stop shop and therefore need to notify all 27 supervisory authorities. Now, given the levels of stress that are involved when there's a data breach that's notifiable to one supervisory authority, it's horrific to think what that might mean. So we'll certainly be responding to that consultation, and I would encourage anyone else who's concerned about that also to respond to the consultation. And I'm just looking at the time. I was going to talk a little bit about China, but I think what I'll do just now is I'll pass across to my colleague Alison White in just a moment, and I'll just mention that there's been a lot going on in China in the last year or so. The Personal Information Protection Law is similar in some ways to GDPR as a framework, but in China there's very much reliance on subject consents. So for data processing, there is a huge consent regime, which is quite different from GDPR. But as I say, I think time's not with us. So Alison, I'm just going to pass on to you to talk about what the ICO has been up to recently.
Thank you, Jo, for that summary. As Joanna said, I'm going to talk a bit about what the ICO has been up to over the last 12 months. I think it's fair to say we had a fairly slow start to the year, but that was largely because we had a new Information Commissioner, John Edwards, who his appointment began in January of 2022. He was previously the Privacy Commissioner in New Zealand, so obviously has a good pedigree in terms of privacy expertise. He started the year by going around the various regions and talking to stakeholders and asking what they wanted from the ICO. And on the back of that, they've come up with a 3-year plan called ICO 25. And what they're trying to do, there's sort of 4 main aims from that plan, which is about empowering you through information. So they want to empower members of the public to confidently contribute to a thriving society and sustained economy. More importantly, for the people on this call, they want to empower organisations to plan, invest and responsibly innovate and grow, so helping them with compliance. They want to promote openness and transparency in public bodies, and they also want to promote enforcement, or rather that people will hold them to account in the way that the ICO enforces the various laws that they oversee. They've set out their first year plans, and there's a number of areas they're going to look at, including focusing still on children's privacy, which I will mention, also predatory marketing calls. But in terms of actually helping businesses, what they feel is there's a number of things that they could be doing, and they are hoping to save businesses at least 100 million across the next 3 years. And to do that, they're going to do various things. They're going to publish internal data protection and freedom of information training materials. They're going to create a database of ICO advice and opinions that they've given to both organisations and the public. They're going to produce a range of templates. Now, obviously, there are a number of templates already on the ICO website, but they're going to increase the number of those templates. They're also going to create a moderated platform where organisations can discuss issues and try and benefit from the experience of other organisations. They're also going to provide data essentials training, and they're also going to do something which create something called iAdvice, and what they see that would be early stage advice for innovators. So at the moment there's something called the regulatory sandbox, but that's for more developed technologies where they can be put through their paces, if you like, by the ICO to see whether or not they are GDPR compliant. But what they want to do is provide an early stage advice service, and that's what iAdvice would do. So, as I said, having had a relatively slow start, things are obviously picking up pace, and we've had a number of pieces of guidance which have been published in the last few months. We've had one of the projects that they're doing is updating the Employment Practices Code, and we've had two parts of that which have been published in the last week. An update of the Monitoring at Work guidance and an update of the guidance on processing information about workers' health. There's also further work being done on the journalism code, and a questionnaire has been issued looking for further information about how data protection is used within journalism. There's also been guidance on privacy enhancing technologies, which is part of general guidance which is being developed on anonymisation, pseudonymization and privacy enhancing technologies. That's out for consultation, and it's hoped that the combined guidance will be finalised early 2023. Also guidance on the research provisions of the GDPR and Data Protection Act 2018, and also finalised guidance under PECR in relation to direct marketing using electronic mail and live telephone calls. Just to mention briefly a couple of those guidance that's been published. On the Employment Practices Code, obviously, as I said, it's part of the bigger project of updating the code as a whole, but one of the things that, obviously in relation to monitoring, we've seen a huge move to home working as a result of the pandemic. So the way in which technology is used to monitor employees, the developments in technology as to how employees can be monitored has obviously seen a significant development in this area. So the guidance is obviously trying to take account of these new types of monitoring that is going on, but fundamentally the principles remain as to decisions that have to be made as to when monitoring can take place. Coming back to the ICO plan to try and be more business friendly or help people with their compliance, one of the things that they particularly mention in the draft monitoring guidance is that they know that organisations appreciate case studies and appreciate worked examples, and so they have tried to do more of that, particularly in the second section where they answer specific questions about different types of monitoring. Similarly, in relation to the health guidance, they have tried again to provide more examples of where of situations where employee health data may be processed. Similarly, we have I've also mentioned the guidance which has been published, the updated guidance in relation to PECR, the Privacy and Electronic Communications Regulations, which is another piece of law which we have kept following our leaving the European Union. So this is the guidance which basically covers use of cookies, use of or how we can use email marketing and telephone marketing, and we have to comply both with the direct marketing rules and also the requirements of the Privacy and Electronic Communications Regulations if we want to carry out any marketing of this type. Just to come back to Seraphine's talk, the other aspects of the Data Reform Bill actually touch on some aspects in relation to updating this type of marketing and indeed use of cookies. I think there's a general feeling that cookies and use of cookies needs to be reformed. And certainly that is something that the UK government is looking at in the Data Reform Bill, as Seraphine says, if it ever progresses. But they are trying to reduce the number of situations where consent may be required, and where to widen where there is no requirement for consent, particularly in relation to use of analytics cookies. Another aspect that the Data Reform Bill is looking at is in relation to the soft opt-in, which is the idea that if you have obtained an individual's details that for one type of purchase, or they've indicated interest in one area, that you can, in certain circumstances, also market to them other related information, products and services. At the moment, that only applies to commercial organisations, but there is an intention, if this Data Reform Bill progresses as originally drafted, to extend that to non-commercial organisations. I think just on enforcement, the ICO has been busy in this front, some of it more substantial than others. One of the ones I'd like to mention is the work that they've been doing in relation to data subject access requests, or DSARs. What has been happening here is that a number of investigations have been undertaken where, as a result of complaints which have been notified to the ICO, patterns of non-compliance have been identified by various organisations. So that is actually a key point to take on board, because clearly, one minor breach may not be something that gets the ICO discussing your compliance with you, but once patterns begin to develop, then obviously they are going to take further action and conduct investigations. So what we have here are 7 public sector and 1 private sector body who have all been issued with reprimands, and that's for failure to comply with the provisions in the UK GDPR in relation to how you respond to and the timescales for response for data subject access requests. They've got between 3 and 6 months in which to improve their practices, and assuming that they do so, there'll be no further enforcement action. However, the ICO will be looking for that further action to be taken, and it's possible we could see further enforcement action if they fail to get rid of largely its backlogs of DSARs which have not been complied with within the timescales. We're also starting to see some more fines coming through. Obviously, we see a lot of fines coming through in relation to breach of the privacy and electronic communications regulations, a lot of spam emails or inappropriate marketing calls. There's been a number of fines in this area. But in relation to the UK GDPR, we've had a couple of interesting fines in the last month or so. First of all, 1.35 million against a company called Easy Life. And that related to the fact that they were a healthcare product provider, but basically what they were doing was they were identifying that if you bought certain products that indicated that you had certain health conditions. So for example, if you bought something to help you open jars, they thought that might indicate that you had arthritis, and therefore started marketing arthritis-related medication and similar products to you. So clearly that did not comply with the fairness and lawfulness principle of the UK GDPR, and therefore the fine was issued following the investigation. We also had another fine last week for 4.4 million, and that was for Interserve, who are a construction company. There was an incident which resulted from a phishing email, and that allowed access to over 100,000 employees' data. And announcing the fine against the Interserve Commissioner, the UK Commissioner warned, basically, if I think that you're not taking account of warnings to update software, you're not ensuring procedures are in place to monitor for this kind of email in the business, if you're not training your staff properly, if there is a breach, then you are going to find yourself on the same side of action as Interserve has as well. So the more that you can show to ensure you're trying to take steps to avoid this kind of situation, the better that's going to be if there is a breach situation for you. Another potential fine is in relation to TikTok, where they're looking at a potential 27 million fine as a result of a number of failures, particularly in relation to children's data. And that leads me on to mention the age-appropriate design code, which is something the ICO is quite rightly very proud of. That came into force in September last year, but it's already being used as a basis for other changes in relation to children's privacy throughout the world. And if you are providing services where you are potentially, even if you're not targeting children, that it's possible that you need to take account of the age-appropriate design code. And that's something that you need to take advice on to see whether or not you are actually providing services and how you design your services to ensure that you are respecting children's privacy. There's already been a number of changes which the ICO have seen over the last year, largely in relation to big tech. For example, Facebook and Instagram have limited targeting to age, gender and location for under 18s. YouTube has turned off autoplay by default and turned on take a break and bedtime reminders for default for Google accounts for under 18s. So a number of things have been happening which have justified the ICO's action in this area. And as I said, it's still going to be one of their areas that they are continuing to focus on. Finally, I'm conscious of time. The other thing I would mention that they have recently announced that they're going to focus on as well is in relation to facial recognition technology. They see this as a very early stage technology where there's a lot of potential for misuse of the technology as such, but the technology is not sufficiently developed in the way it processes personal data. And they see this as an area where there needs to be significant guidance. There was an announcement on this last week, and it basically is a warning from the ICO if you're using such facial recognition technology to be aware of what you're doing, and that they're hoping to provide guidance in early 2023 on this area. So as you can see, the ICO has been very busy over the last 10 months, and I think we're hopefully going to see more in this area. And as Joe said, the one area we're particularly looking for is further guidance in relation to international data transfers.
Thank you very much indeed, Alison. So we are currently at 10:56. We've got a couple of minutes, I think, for questions, and we've had a couple of questions. The first question that we've had is, I'll paraphrase this. You've got, on the one hand, the EU Commission at odds with the Dutch regulator and in favour of allowing commercial interests. On the other hand, potentially against, or at least not yet approving, of the UK-US arrangements to share data for law enforcement. Is data protection now more political than practical? That's a very good question, very good question. And I think obviously in all of these things there are politics. And then the other question, is it going to be possible to simplify data protection regulation for businesses that do not transfer data cross-border? And the UK Data Reform Bill, I think, seeks to simplify some of that. A lot of the complexity is in the cross-border transfers. But I think we'll just need to wait and see what the Data Reform Bill does. Got another question. Seraphine, do we have an indication of the timing of the Data Reform Bill?
I think that's the big question, and there is no indication. There wasn't even an indication under Liz Truss, and now that we have a new Prime Minister, I think it's even less unclear kind of what the next steps are. So as of right now, everything's on hold, and it's just a space to watch.
Thank you for that. Another quick question. What are the chances of the EU granting adequacy to the US? I think the chances are quite high. Commentators seem to think that it's quite likely, and if it goes to a vote, there may be some abstentions, but likelihood of the EU giving an adequacy decision for the US, reasonably high. And I think just one more question.
Sorry, I was just going to add to that, Joe. It might be high, but there's always Max Schrems in the background who'll be quick off with another challenge, and we'll have Schrems 3 before we know it. So yeah.
I think that's absolutely right. And as I said in my talk, you know, we had Safe Harbour, then Privacy Shield, SCCs which were challenged, and I can't imagine either that Max Schrems will leave an adequacy decision to lie. And then I think this is probably one for you, Alison, actually. Just looking at the working from home, to what extent can businesses monitor employee devices to track productivity?
Well, I think it's really applying the same principles that we've always had in relation to monitoring at work, which is, you know, what is the reason that you're trying to do this for? Certainly the ICO would look to see you carry out a data protection impact assessment, so you could address what it is you're trying to do, and also look at how you can perhaps minimize the data, you know, make sure you're not repurposing it, and certainly it's also about transparency and making sure that you have told the workers, or perhaps even consulted with them about what actually is happening.
Great, thank you. So we're now at 11 o'clock. Thank you very much indeed, everyone, for attending this update. And if you do need any help with your data transfers internationally, and particularly in preparing for the December deadline, please reach out. Thank you very much indeed.